If you're a sales representative who is not being paid commissions, this video is for you. I'll answer some frequently asked questions. My name is Aaron Hall. I'm a business attorney. I have regularly represented commissioned salespeople, typically after they're terminated from the company. Now, you typically see two different types of commissioned salespeople. One option is employees. The other is independent contractor. And it's important to figure out which you are right at the beginning because your rights are very different. Employees have all the rights of Minnesota employment law, a right to prompt payment of wages, for example. There are plenty of other rights there. But then, for an independent contractor, the sales representatives have a significant statute that gives them protection. Now, let me explain to you why this statute exists. There was a problem. Manufacturers would hire independent sales reps to build the customer base, or maybe it's pull in some retailers and establish relationships for the manufacturer. And the manufacturer would say, I'm not going to pay you anything right away, but you will get commissions over time while we have that relationship. So these independent sales reps would go out and establish business for the manufacturer, sometimes working months or years to get that business set up. And then once it got set up and it was thriving, the manufacturer said, thank you, goodbye, I'm ending the relationship. And now the sales representative would stop getting a commission from that relationship. Well, this became such a problem that the Minnesota legislature, as well as legislatures throughout the United States, established the Termination of Sales Representative Act. It's known by slightly different names throughout the United States. But what it does is it establishes a sales rep's right to commissions. If they're going to be terminated, it sets forth a process for how that termination should occur and notice that needs to be provided. In general, here's how it works in Minnesota. A manufacturer can terminate and by the way, it depends on the terms of the contract, but let's assume it's an automatically renewing contract. The manufacturer has to at least give 6 months notice that they intend to not renew the contract. And if there's a breach of the agreement, the manufacturer needs to give 90 days notice to the sales rep in order to try to cure that breach. That means, in other words, that if the sales rep has failed to do something the manufacturer requires under the sales rep agreement, the sales rep has 60 days to try to cure or fix that issue in order to avoid the contract from not being renewed. Now, what happens in a situation where a manufacturer just says, you're done, we're terminating you, no notice period? You, as an independent sales rep for a manufacturer, have significant rights in Minnesota. You have a right to have your attorney's fees covered by the manufacturer. You have a right to commissions during the notice period, and you may have other rights as well. Often you need an attorney to assert those rights. They're typically not going to be just offered by a manufacturer. And I see pretty regularly that we need to do litigation in order to get the manufacturer to actually pay out. Often manufacturers are not aware of this important statute that was specifically designed to protect sales reps. Now, there are a lot of details here that are important to look at. For example, it's not just manufacturing reps. It's sales reps who represent other types of businesses in the chain of distribution. And there are other rules and restrictions on this. For additional information, see the link below. I'm Aaron Hall, an attorney in Minneapolis.